Welcome, everyone. Go ahead and take a seat. This is the third program in the Bolts Judicial Institute's Fall 2025 Star Rule of Law series, exploring the importance of the rule of law to democratic institutions and the judiciary's role in maintaining it. The series is sponsored by the Elizabeth and Stanley Starr Rule of Law Fund, which was established earlier this year by Duke Law donors and friends of Elizabeth and Stanley Starr, who are the generous donors behind Starr Commons, a Starr Professorship, Starr Scholarships, and much more. Today's discussion, threats to judicial independence and the rule of law, could not be timelier or more relevant. Federal and state court judges are increasingly facing public attacks and personal threats from individuals and organizations that are unhappy with judicial rulings. The frequency and tone of these threats prompted U.S. Supreme Court Chief Justice John Roberts to write about the issue in his 2024 annual report on the federal judiciary. He acknowledged that criticism of judicial rulings is important to improve the work of the courts and protected by the First Amendment. But, he wrote, violence, intimidation, and defiance directed at judges because of their work undermine our republic and are wholly unacceptable. We are honored to have a distinguished panel of jurists and practitioners with us today to consider how judges, lawyers, and legal institutions can respond to these challenges and help safeguard judicial independence and strengthen public confidence in the rule of law. Our moderator, Judge Robin Rosenberg, of the U.S. District Court for the Southern District of Florida, currently serves as the director of the Federal Judicial Center. A Duke Law graduate, Judge Rosenberg has worked closely with the Bolts Judicial Institute on its Defending the Judiciary and Civics Break programs, and recently concluded a term as chair of the editorial board for Judicature, the Institute's journal about judging. Judge Beth Bloom also sits on the Southern District of Florida. She previously served 15 years as a Florida Circuit Court judge. She and Judge Rosenberg co-founded the Civil Discourse and Difficult Decisions Initiative, which is a national civics education program that many of you, of our students, may remember participating in during your first year of law school. Between Judge Rosenberg and Judge Bloom is Chief Justice Cheri Beasley, who served as a judge in North Carolina for more than 20 years, including 8 years on the North Carolina Supreme Court. In 2019, she became the first African-American woman to serve as Chief Justice in North Carolina. She is also a graduate of the Bolts Judicial Studies LLM program here at Duke Law School, and now serves as the inaugural Justice Sandra Day O'Connor Professor of Law at Elon University School of Law. And finally, Scott Atherton is managing partner at Atherton, Ghilardi, Mullen, and Reeder in West Palm Beach, Florida. He serves on the Bolts Judicial Institute's Leadership Council and brings a practitioner's perspective on public discourse, judicial threats, and the responsibility of lawyers and bar organizations to defend the judiciary. Thank you all for joining us today. Judge Rosenberg, take it away.
Hey, well, good afternoon. Thank you for those of you who took the time out of your schedules to be here. It really says a lot about your, I know they're serving lunch, but of your interest in this very, very important topic. It's wonderful to be here and to address the important topic of the current threats to judges in the judiciary. We should all care about this topic, whether we're law students, lawyers, or judges. And today you're going to learn why. I want to thank Duke Law for being such a national leader in all of the efforts to defend the judiciary. Let's begin our conversation with some troubling statistics. In FY 2025, the U.S. Marshals Service reported that 562 credible threats had been made against sitting federal judges, as well as 395 unique judges identified as targets on protective investigations. While there are no nationwide statistics relating to threats against state court judges, reports from the National Center for State Courts and individual state judiciaries and news stories reflect sharp and alarming increases in threats against state court judges who, like their federal counterparts, have experienced harassment, doxing, online attacks, and security incidences at their residences. Regrettably, these attacks increasingly are being made by elected officials who are upset with rulings that judges have made in cases assigned to them. In dismissing the lawsuit filed by the Department of Justice against all the district judges in the District of Maryland, Judge Thomas Cullen, who was appointed by President Trump, listed some of the slurs being aimed at federal judges, saying, and I quote, "Indeed, over the past several months, principal officers of the executive and their spokespersons have described federal district judges across the country as left-wing, as liberal, activists, radical, politically minded, rogue, unhinged, outrageous, overzealous, and unconstitutional, crooked, and worse. Although some tension between the coordinate branches of government is a hallmark of our constitutional system, these concerted efforts by the executive to smear and impugn individual judges who rule against it is both unprecedented and unfortunate." That's a quote from the judge. Similarly, in his 2024 report, as the dean indicated, on the state of the federal judiciary, Chief Justice Roberts has noted the troubling increase in the attacks. And he recognizes that there's a First Amendment right to criticize judges, but there were 4 things that crossed the line from protected speech to unfair attacks: threats, attempts to intimidate, misinformation, and calls to disregard judicial orders and judgments. So let me turn to our esteemed panel. Judge Bloom, if I can start with you. Your perspective on attacks against judges and the judiciary is informed by both your service as a U.S. District Judge, but also you chair the Judicial Independence Committee of the Federal Judges Association. Can you take a moment to explain to our audience what the Federal Judges Association is and why it views the type of attacks that we have been seeing as a serious problem that must be addressed?
Thank you for having me. So let me tell you a little bit about the Federal Judges Association. It was founded in 1982. It's a national association of federal judges that are appointed under Article 3 of our Constitution. So we know they're all United States district judges and circuit judges. The association has about 1,200 members, and the association supports the organization through its dues. Its officers and directors come from the federal courts of appeal and the district courts who actively work within the organization. Obviously, the Federal Judges Association is committed to a strong, impartial, and independent judiciary, and it works to sustain our system of justice. Toward that end, the FJA supports civics outreach and educational programs. We work collaboratively with the Administrative Office of the U.S. Courts and matters of shared interest, for example, the judiciary's budget and certain legislation. And we also host a quadrennial every 4 years in Washington, D.C., which includes receptions and meetings with the Supreme Court and obviously bringing the judges together. The FJA is also a member of the International Association of Judges, which is an organization that studies common interest to the judicial process on a comparative and transnational basis. I serve on the executive committee and I chair the Judicial Independence Committee. And in doing that, I oversee what's called our Champions for Justice effort. Our Champions for Justice effort works with stakeholders, and those stakeholders throughout the country include the public, the legislative branch, portions of the individuals in the legislative branch, retired judges, former attorneys general, bar associations, and other organizations. And the goal is twofold. One is for those organizations to promptly respond to unfair and unjust criticism of judges. And the second is to educate the community about the rule of law, the need for civility, and the importance of an independent judiciary. And much of that is focused on disinformation and educating the public. The 2 strong partners that I do want to emphasize are, one is the tremendous work of the Bulge Judicial Institute, and it's Defending the Judiciary Initiative. That's led by, as we know, Judge Paul Grimm and Melinda Vaughn. They've taken the lead in defending judges and protecting our judicial independence. And also the work of the Article 3 Coalition. I don't know if you've heard of the Article 3 Coalition. Actually, Judge Grimm is a member, but that Article 3 Coalition is comprised of a distinguished group of retired federal and circuit judges, roughly half appointed by Republican presidents, half appointed by Democratic presidents, and they stand united to speak out about the separation of powers and the importance of an independent judiciary.
So following up, Judge Bloom, can you give some examples of the types of threats and attacks that have been made against federal judges?
Sure, and why we view that as important. Let me first start with why it's important and why it's not just a judge issue, but it's an issue for all of us. The simple answer as to why we believe it's important is that the security of federal judges and all of those serving in the judiciary, not just the federal judges, but our state court colleagues, that judicial security is fundamental to our ability to uphold the rule of law and to fulfill our constitutional duty without fear or undue influence. A judiciary that operates under the threats of violence, intimidation, or impeachment risks the erosion of judicial independence, which is a cornerstone of our democracy and our Constitution. And it's really not just about protecting individual judges. It's about preserving the integrity of our legal system and the public's trust in an impartial judiciary. But unfortunately, as Judge Rosenberg said, judicial independence is under assault. In recent years, we routinely have heard false claims from our leaders, the media, and ordinary citizens that courts are just another political battlefield, that judges who issue inconvenient rulings are merely partisan actors, overstepping their constitutional authority and undermining the separation of powers, all to score political points for the party of their choice. And some people just don't understand why their political or moral view on an issue is rejected by unelected judges. And that misunderstanding breeds mistrust, which is inflamed by some politicians who accuse judges of being un-American or corrupt based solely on the judge's ruling. And for some, that mistrust breeds contempt, and some seek to do harm, and that's where the attacks come into play. But we all must have the courage to say that false claims and threats aren't just wrong, they strike at the very foundation of what separates a nation of laws from a nation where might makes right. So I want to reemphasize that criticism of the government, including judges and their decisions, is not just permitted, it's actually essential. The founding fathers ensured that petitioning the government was one of the first and most important freedoms that were protected by our Bill of Rights, and robust debate of judicial decisions has always been part of our democracy, and it actually should be. But something fundamental has changed. In recent years, the disinformation and the attempt to politicize the judiciary has transformed rational disagreements about the reasoning in a legal decision into threats of violence against dedicated public servants based on their perceived political persuasion. And as we've seen, hateful and toxic rhetoric has put judges, their families, and judicial independence at risk. And I should say that when judges and their families receive death threats for following the law, when courthouse security must be increased because of credible threats of violence, and when judicial staff fear for their safety, that is not democracy in action. It is democracy under siege. And one strengthens our system by holding it accountable. The other undermines it by making judges choose between their safety and their duty to uphold the law fairly and impartially. We've already heard about the statistics from the Marshal, and we know that threats have surged in recent years. But you know, those threats used to come from those who lost a lawsuit, but now they come from anyone that's inflamed by social media, either their posts or public statements, or sometimes elected politicians. And sometimes those threats come without warning. And in the past, they were often forewarned by a threatening letter to the judge, and then alerted by that letter, the U.S. Marshal Service could respond to specific threats. But the U.S. Marshal Service may be well equipped to respond to a threatening letter, but less so for today's anonymous surprise attacks. And that includes many of the threats that I think we're going to talk about.
Okay, thank you. Chief Justice Beasley, you've served as a state trial judge as well as a Supreme Court justice, and you too have been the target of personal attacks. Can you share your thoughts about why threats to state courts also seem to be on the increase, and why this is a matter of concern, and maybe for the benefit of our audience, explaining a little bit, as we asked you last night about North Carolina and the nature of judicial elections being of a partisan nature, which is a different experience that Judge Bloom and I had as state court judges in Florida. So you really have had a different experience than we have as state court judges.
So in North Carolina, all judges are elected. For the most part, there are a few exceptions, but district court judges are elected. Most superior court judges are elected, both of which are trial judges. Members of the Court of Appeals are elected, as are the members of the Supreme Court. And in North Carolina, many courts, high courts, the Chief Justice is chosen by the justices. But in North Carolina, you actually run for the office of Chief Justice. So the electorate elects the Chief Justice. I think we know so much more about threats and violence against judges because social media is accessible to everyone, and so we hear more about these kinds of things. But I mean, frankly, I remember in the late 90s being in Cumberland County, Fayetteville, and we had bomb threats literally every single day for 2 years. And thankfully, law enforcement took them seriously. We cleared the courthouse. But you can imagine logistically what that meant for hearing cases and making sure that folks truly had access to justice. So I think we just have access to more information now. But frankly, it was not uncommon at all when I was a trial court judge, sitting in domestic court for litigants or witnesses or family members to make threats to the court or to the judge or to a member of the court staff. It just wasn't that uncommon. And thankfully, again, law enforcement took those threats very seriously. I'm glad we have heightened awareness about the dangers of surrounding service in the judiciary, federal and state. And I'm also very thankful that there are organizations like Judge Bloom and Judge Rosenberg have founded to make sure that people are aware. Because this really is not just about violence, which of course is horrendous, but it really is about the independence of the judiciary. And the message that some will send to let judges know that if you don't rule in a certain way, number one, we may know where you live. And so I'm sure you all have heard of pizza doxing, where federal and state judges have received, 100 pizzas or 50 pizzas or whatever that is, and that they didn't order, right? And there's other kinds of doxing. So the threat is real. I can tell you from my own experience when I served as Chief Justice of the Supreme Court of North Carolina, and when I was Chief Justice, I also had an election. And so there were people who were calling my chambers and they were using nigger, bitch, all kinds of language around why I should not be in service, and also about the rulings that I had made or the court had made in cases before the court. We had folks who were coming to our home. I'm married and have twin sons, and so we were deeply concerned about what was happening. And part of that time, my sons were away at college, two respective different colleges, and they had security. They needed security, and we had security at our home. And so I thought about not just our family's safety, I thought about our neighbors, and I thought about what they would do. The police presence was huge at our home. And I also thought about what it would mean in terms of the work of the court. I mean, to know that this kind of targeting is happening is really quite frightening. One of the questions you asked before we got here was, how do you have hope and how do you versus, recovery from this? And frankly, I still have a bit of trauma around the fact that our family was targeted in that way and that we could see people headed to our house. But for not just law enforcement, frankly, but our neighbors who were phenomenal, who would sometimes stop people who they knew were not supposed to be on the street and were there to cause trouble. It has been quite an experience. I also ran for the U.S. Senate after that, and we had the same thing happening, so I had security then. And I thought about, what does that mean for the public, and what does that mean about your trust and confidence and the people around you in our court systems and in our legal processes, period, especially when I was running for the U.S. Senate. And so it is dangerous. I know of so many other judges who have experienced threats to themselves and to their families and their homes. And I'm thankful that there are so many folks, and I thank you so much for your leadership around this really important issue, because the word is getting out that not only is this dangerous, but that it's intolerable. And that all of us as a society, not just as jurists, have a role and a duty to make sure that it's not just keeping judges safe, it really is protecting the administration of justice and accessibility of courts. And many of you are not quite lawyers, but our rules of professional responsibility tell us that we are not just officers of the court, but that we are officers of the legal system. And that we have duties as public citizens, as advocates, as lawyers, as judges, to make sure that the information that people receive about courts is accurate, and to promote the rule of law. And so I'm really delighted that we're here today having this conversation, because the more we have these conversations about the critical nature of what's happening with judges and with courts and with the independence of courts, which we all want, the more you all will hopefully also be ambassadors for this really great charge.
You're giving away the pitch that we're going to make at the end of the talk. So listen carefully, because when Justice Beasley talks about hope, I think how I interpret that is for us to look out into the room, and we're going to explain why you are our hope, truly. So it's a big challenge to put on your shoulders, but it's an important one, and we think you are really the best group, meaning you collectively, your generation, you as law students, even if you're not a law student, but idealistic and hopeful, and wanting a better future than maybe what we have now, and it is possible. Scott, as you know, lawyers, doctors, and members of the military are unique professions because entry into the profession requires the taking of an oath to support and defend the U.S. Constitution, and for attorneys to defend the judicial system and individual judges from unfair attacks. The law students in our audience will soon be taking that oath for themselves. Can you comment from the perspective of a practicing attorney about the ethical responsibility of members of the bar and bar organizations to defend judges and the judicial system from unfair attacks?
Absolutely. Good afternoon. How's everybody doing? Good. A lot of munching going on, so that's good. I'll address two things. The first is I do want to talk to the group about what lawyers' ethical obligations are, things they're supposed to do and things they can't do, and how all of you who pass the bar or take the bar will sign an oath that requires you to do the things I'm going to talk about. And after I discuss what those duties are that lawyers have, I'm going to talk very briefly about what private lawyers can do to discharge those duties. So very quickly, on the ethics portion, there are two mandates you'll have to consider once you become lawyers. The first is you have a duty to defend the judiciary and the rule of law. And that is in the model ethics rules. Virtually every state across the country, including my home state, Florida, make that an express part of their ethics rules. So what we're talking about here today is actually something that's in every citizen's interest. We have so many rights. We've been so spoiled compared to others across the world. We have so much we take for granted. We have property rights, right? Hopefully you all have bank accounts. that somebody can't just go take your money with no recourse. If that were to happen, your recourse is with the judges. We have privacy rights. You know, people can't wiretap us without probable cause and other measures that you guys are learning about in your classes. We have those rights because of judges. We have civil rights. You know, we have the right to determine our own religion or no religion or who we want to consort with or who we want to marry or whatever the case may be. Those legal rights, those all come from judges. And when judges' ability to do their job in enforcing the law is compromised, then all of our rights are compromised. So I just want to talk about these ethics rules for the lawyers in here, but the importance of this, I think, permeates every citizen. Unfortunately, I don't think citizens understand that because we've never before been in a period of time where an impartial judiciary was under such stress. So there is this ethical duty to defend the judiciary. In addition, there are certain things lawyers are not allowed to do. First, you can't impugn the qualifications or the integrity of a judge. So it is true, you can disagree with a judge's opinion. In fact, as a lawyer, I do litigation in court. So sometimes my duty is to disagree with that judge. But it's all about the way you do it. We don't do it by suggesting the judge that ruled against us that there is something wrong with them or they are corrupt or they are illegitimate. We do it by a fact-based, law-based disagreement. And of course, you have the recourse of an appeal in most cases if you don't like a judge's ruling. Another aspect of the ethics code is lawyers are prohibited from engaging in conduct that would prejudice the administration of justice or disparage a judge. And so these are among the things you'll have to consider as you become lawyers and you take an oath, because there's yet another ethics rule that says if you become aware of another lawyer who violates the things I've just talked about, you have a duty to report that lawyer to your state bar. So this is a good foundation for understanding why this is important to everybody, why it's particularly important to the people in this room who want to become lawyers, and why this is such an important cause for all. And another question I think I'd like to discuss is, how well is the bar dealing with this, the private lawyers, and what can private lawyers do? And I think the best way to express that to you might be my own personal experience. I have observed, either through direct observation and through the media, all of these attacks on judges. And to be clear, this is not a partisan issue. You know, certain people might think that it's only crazy people in one political party who attack these sorts of judges, or vice versa. And it is a nonpartisan topic where it doesn't matter what somebody's politics are. There are extreme people on every side on a 360-degree, perspective of the spectrum. And judges of all manner are subject to these attacks. So this is a nonpartisan issue that we are dealing with. And unfortunately, many private lawyers don't see how they can help tackle such a big issue. And I was one of those. And it actually wasn't until I spoke with Judges Bloom and Rosenberg where I understood everybody, every law student, every lawyer, every citizen can play a role in trying to help. And there's a couple ways you can do that. And the first is educate yourself. That's what all you guys are doing here. So you're already on the road to helping discharge this important responsibility. And when I say educate yourself, it is learning about not just the problems judges are facing, really reflecting on how this really is everybody's problem, and considering how you observe this in your own daily life. I don't know about you, but I have been at dinner or speaking with friends or at the proverbial water cooler at work, and some important policy issue will have been addressed by a court. And so understandably, it's a topic of discussion, and that's not a bad thing, because we're in a country where we're supposed to have a competition of ideas, and we're supposed to be able to speak freely. But sometimes those conversations take a dark turn, where instead of saying, I disagree with this court ruling as a matter of my own values, which is completely appropriate, to attacking that judge or wishing harm on that judge. or saying, I hope that judge gets what they deserve, that sort of conduct. And when that happens, what each one of you could do is have a plan for how you react. And what I suggest is the first step in that plan is to not get upset yourself. In my own personal observation, I've been involved in discussions where somebody makes an outrageous comment, something that strikes against my core values, and the first thing that happens is I feel my body get angry. And when you feel your body angry, it's very hard to have a productive, nonpartisan discussion with somebody. So I would say step one is sort of understand that you may have that reaction, and if you do, it might not be a good time to engage. But if that is not a challenge that you're facing, you should consider educating people instead of debating them and fighting them on a matter of policy that might be deep and true to their heart, which they are misinterpreting as a reason to attack a judge. It's helpful to educate them. And so let's talk about some very simple matters that if most citizens knew, I think a lot of this rhetoric would reduce. Number one, judges do not pick the cases that they get. I'm sure a lot of judges get randomly assigned a case and they are saying, crap, maybe not that, but that's what I might say. So they don't pick the cases they get. So that's number one. Number two, sometimes they have to rule in a way that they may not personally like because their job is not to do what they want. They're not empowered to do what they want. Their obligation is to follow the law of higher courts. And so if you were to talk to a citizen or a layperson, why isn't it fair for me to criticize these judges in this way? And the answer is because this is somebody who is a public servant, who was assigned this case, whether they liked it or not, had to follow the law, whether they agreed to it or not. And if that judge made a mistake, and judges sometimes make mistakes, then the proper procedure is to appeal. And of course, if the problem is the judge actually decided it right, but the law is what a citizen doesn't like, then there's a remedy for that too. You can lobby to try to change the law. So what I would respectfully submit to the group is educating yourself on these issues, understanding that they can become emotional, and making sure that you're not feeding that fire inadvertently, and trying to, instead of argue whether the ruling was right or not, whether the policy decision is right or not, maybe just educating others on some of these factors that indicate judges are just doing their jobs. All these judges who are being threatened and people are coming to their homes, and the pizza doxing we're talking about, where pizzas are being sent to judges in the name of the son of a federal judge, a son who was murdered protecting his mother who was a federal judge. You think you got sent a pizza, a big deal. It's a big deal. That is somebody making a death threat. If you were to search up after this presentation, death threats by pizza doxing, you'll read all about it and you'll see what I'm talking about. So you all have a chance. I understand nobody is standing in front of a judge's house, to physically protect them, and that's not what's being asked of private lawyers and law students. But if we can intervene at the early stages of this dialogue, where people start at the top of a hill with a big snowball that ends in a serious judicial threat, and we're educating the public, we can really bring down the temperature of these discussions and really do good, not just for the judges, but for ourselves, so we can preserve these public servants' ability to protect our rights.
Thank you, Scott. So you've spoken really eloquently about the role of law students, of lawyers, actions that you've taken, that you're trying to encourage other law firms and bar associations. Judge Bloom and Justice Beasley, what can judges themselves do to address these attacks against our judicial system? It's somewhat complicated by the fact that sitting judges are ethically prohibited from speaking publicly about cases assigned to them or issues that may come before them to be resolved in a case assigned to them. But they're not entirely powerless to engage with the public in a manner that promotes respect for and confidence in the judicial system. Can you share with us what our judge colleagues can do during this time?
You want me to start? Okay. Well, let me give you some statistics in terms of our civics literacy when we landscape the public. Because a recent survey revealed that more than 50% do not know the number of members in the House of Representatives. And only 1 in 3 could name or explain the work of the 3 branches of government. That tells us that there's illiteracy when it comes to civics in our country. What we can do as judges is what we've already been doing, and that is to educate the public. We can't speak about cases that are before us. We can't speak about issues that are likely to come before us. But we can certainly educate the public on issues of the rule of law, judicial independence, certainly civility, and our basic 3 branches of government, separation of powers, the role of the court, that the court is not a branch that is political in nature, that the act of selecting judges may be, in terms of federal judges, right, even on the state level, with the governor, but with the presidential appointment, but the act of judging is not political. We may have cases that are controversial in nature, but the act of judging is not political. So we can certainly educate the public. We have, do you want to talk about it now, or should?
You can go.
Okay. So we have started a program to educate the public. I think you were part of our Civil Discourse and Difficult Decisions program that was geared for high school students, college students, and now law students. You are here because you want to make a difference. And we've started a program called Courts and Civility. It is a very simple program. It has 3 components. One teaches about judicial independence, one about the rule of law, and one about civility. You are well equipped to explain the 3 branches of government. You are well equipped to explain Articles 1, 2, and 3 of our Constitution. You are well equipped to go out and be leaders in the community. And that's a program that we started. It is now a national program. The Federal Bar Association. Is anybody involved in a student chapter for the Federal Bar Association? Well, actually, to be a member of the Federal Bar Association as a student is free. So I would encourage you, you can just go on the Federal Bar Association website. But that's a plug for the Federal Bar Association because it is a wonderful organization. And there are student chapters throughout the country as well as chapters where lawyers are involved. But the Courts and Civility program is now a national program through the Federal Bar Association and is one of their mission projects. Why is that important? Because the Federal Bar Association, as well as many organizations, knows that it's critical right now that we educate the public. So judges are going out to teach about civics, and you can certainly do that as well. And I know that the Dean spoke about, actually Justice Beasley spoke about being an ambassador of civility. You have a perfect opportunity through this program to go out and educate the community, be the leaders that you all are, but now be the educators that we need you to be. And so that's what judges are doing, and it's certainly what we all can do. And that is to pay it forward. Take that wonderful privilege that you have to be in law school and learn. All of you understand what the Constitution is. All of you understand 3 branches of government. Now go out and teach it to those individuals that really need to know. And they need to know from those of you that are the future. You're the future leaders of our country, so we really need you. We've been doing the work. Now we need you to come in and share the work with us.
You know, and I told you that in North Carolina, judges are elected, and in about 37 states in the nation, judges are elected in some form or fashion, either by retention vote or outright elections like we have here in North Carolina. And increasingly, because of social media and other ways that folks have access to information, people are starting to pay attention to what's happening in courts in a way that they just traditionally have not. And so it really is important now that people are thinking about what courts do, probably not in an extensive way. I mean, there's sort of sound bites of the information that people have about courts, and people want to know which president appointed the jurist, because that in some way may indicate what the outcome of a case may be, which I think is incredibly misleading. And same for governors who fill vacancies in state courts here and across the country. The other piece of that is so many judges are required, not just in North Carolina, but across the country, and the federal judges. We're all under a code of ethics, a judicial code of ethics. And there's a financial disclosure requirement around to in some way help people glean whether or not one may have a conflict in a case or potential conflict. The level of information that can be available for judges' lives and their addresses and how many children they have and where they live and all of that is readily available. And so one of the things that judges and ambassadors and lawyers can do is to really lobby against that. I mean, it's frightening to think about the fact that there's such access to information about who judges are personally and who their families are and where they live. That information really, I very much appreciate disclosures around financial interests to determine whether or not, for yourselves as members of the public, whether or not there could be potential conflicts of interest or whether or not there are conflicts of interest. But to have that level of access to information about judges, it's incorrigible. It just should not be the case. So it is really important, I think, for all of us to really push in our respective areas to make sure that lawmakers know how important it is for that information not to be public. And I'll share with you, there was a year on our Supreme Court where 5 justices, I was one of them, had false tax returns filed in our names because of information that had somehow been accessed. And so it is really dangerous. And once again, it is one of those ways that I think the intent is to impact the independence of the judiciary. Thankfully, I really do not believe, I sincerely do not believe that even with all the pressure that judges cower to that pressure. I do think it's important also as we think about the context in which judges are elected. I mean, you know far more about elections than you would have 5 years ago because you see high court elections where $90 million is invested in one race, and you see judicial candidates taking public positions on issues that are hot for this country. And so the other piece of that is for those who are on the bench, there's a responsibility to set the standard outside of the code of ethics. I mean, the code of ethics really does speak to that, but how judges carry out and execute their work really does matter. It is, in my mind, completely unacceptable when judges take public positions on issues like elections and abortion, and in some ways open themselves up to a level of scrutiny that doesn't have to exist.
Well, before we open it up to questions from the audience, can each of you give some advice or guidance that you can offer to our law students? But again, I think we have others, well, I know we have others who are not law students. I mean, I think it's kind of general advice and guidance to this generation. They are the future of our country as lawyers, the future of our profession, soon to be lawyers. What can they and what should they be thinking about to help strengthen the public's trust and confidence in our judicial system?
Well, I'm happy to go first. The best piece of advice I could give this group, lawyer or non-lawyer, and really whether we're talking about this particular topic or more generally, is focus on listening. The older I get, whether it's in the context of being a lawyer or not, I realize listening to other people is your most important skill. And listen to what they say and think about what they mean, what they're feeling. why do I raise that in the context of this? Because when you're engaged in a discussion with somebody who may be engaging these sort of unfair or unjust attacks on a judge, I think listening is a very powerful first step to understand where they are coming from. I think that is something that you could carry through if you were to engage not just in some private conversations, but in some broader civics education exercises, because you'll be explaining how the court system works, how the judicial system, how cases are assigned, and why it's certainly not fair to criticize judges in this way. And you may get feedback from people in the audience who may still be interjecting their views. And I would just suggest it's very helpful to listen to those folks, to try to understand them, and rather than debating and arguing everything, as I used to do when I was a young lawyer.
So I'll share two mantras that I live by. One is looking inward in each of you, and one is focusing outward. And it has a lot to do with what we've been hopefully sharing with you, is that this is the time to meet the moment and to do something to help our country. We're at a point where we need you. We need you to go out and educate. The first is looking inward. And if, we all go through challenges, but if you really want to shrink your problems, grow your purpose. And you can do that by being involved in this effort. That's number one. Secondly, is something that all of us have been involved with, and that is throughout our lives, and hopefully throughout your lives, you'll find opportunities. You'll see challenges. You'll see that there may be an injustice, or there may be someone who is not doing as well as perhaps they could, and they need somebody to step in. Throughout our lives, we've been able to, and I think that I can speak for all of us, to see that there are ways to make a difference, whether it's the civil discourse and difficult decisions, whether it's the court's incivility, whether it's now working with the lawyers and going out and educating the public, whether it's educating the public because of what has personally happened. But my second mantra, which I'll share with you, is that problems are only opportunities in work clothes. And if you look at a problem, you can find a solution, but you have to be the one to get to work. And don't leave it for someone else. You're the one that can make that difference. And that's what this world is all about. When it's all said and done, when our time comes to leave the world, we want to look back and hopefully say that we've made a difference. And you're all very privileged to be here. I would ask you to take that opportunity that you've been given and pay it forward. So look for those opportunities and work to make those opportunities solutions. So those are my two mantras for you.
One of the best things you can do is really begin to hone your professionalism and integrity and ethics now as a law student. You give me a lot of hope. I have a lot of hope in my students at Elon Law School. You will be standard bearers very soon. And so much of what happens right here in this place, in this law school, will have great bearing going forward in your professional lives. You all will forever be interconnected in some way, which is really a great thing. You hear horrible lawyer jokes. I never laugh. I don't think they're funny. It is a privilege to serve as a lawyer. It's a privilege to be able to help people and companies and to, in so many ways, make great impacts on our communities and our state and our nation. So be good lawyers and be standard bearers and let people see how you operate. And when you are involved in activities outside of your law work, people will see how you model civility and professionalism. And maybe they'll think twice about telling the silly lawyer joke when in so many ways, much of the goodness that has happened in this country, and in many ways, all of the ways that in which justice has gone forward, lawyers have been the foundation of that. And so I really am excited. There are bad things that happen, but you give me hope. And I don't think that the litmus test is around the bad things that happen and the targeting of judges. The litmus test is really how you go forth, you practice law, you serve in your communities, and the people around you will see the goodness of who we are as lawyers, but they will also, hopefully, your conduct will engender trust and confidence in our court system. So you hear publicity around the things that people don't like, the things that incite, but most of the cases that happen before courts, you never even hear about them. You will know that far more than the people around you. And so please amplify the message that justice, the seat of justice, remains in courts. And that happens not just esoterically, but it happens because of the good work that you do, the good work that judges and other staff people do. So the good news is that there is a lot of hope in the day, and you bring us a lot of hope.